Well, hello everyone, and welcome to the webinar, Employment Law Missteps, How to Avoid Common Pitfalls, which is presented by the Advance Group. My name is Lynn Luther. I'm an attorney and the managing partner of Eastman & Smith's Labor and Employment Practice. We defend companies on all types of labor and employment issues, and we were thrilled that the Advance Group asked us to present this information to you. It is a valuable resource because these are common mistakes that we see companies make frequently. So hopefully by attending this today, you can avoid some of those common issues that we see and, of course, the potential liability that can come with them. This presentation is approved for 1 hour of recertification credit, which the Advance Group will provide to you at the conclusion of the presentation. The first issue we're going to tackle are background checks. Now, certainly the Fair Credit Reporting Act has all kinds of procedural requirements on what you need to do in order to obtain the background check information, but that's not going to be the focus of our conversation today. What we typically see is that companies misuse that background check information in ways that can lead to liability. Just over 5 years ago now, the EEOC issued enforcement guidance on this topic. And the EEOC took the position that certain types of information on background checks can be detrimental to certain protected groups under Title VII. Specifically, they found that there's disparate treatment because employers treat criminal history differently for different applicants and employees, or it has a disparate impact, which means that the employer's neutral background checking policy disproportionately impacts protected individuals. So what does that mean? Essentially, the EEOC concluded that because minorities and other types of protected groups have a disproportionately higher arrest and conviction rate than Caucasian employees, that simply targeting an employee because of a criminal background without taking it a little further can result in liability under Title VII for race discrimination. So what the guidance has instructed on it, all employers to do is essentially put the burden on the employer to defend its screening process. It doesn't mean that we can't do background checks, and we cannot, and we still can exclude people for felonies and misdemeanor convictions in some cases, but we need to look at it with an individualized assessment and no more automatic exclusions simply because someone has a felony on their record. There have been challenges to this EEOC guidance, so it has not been well taken by many groups, but unfortunately those challenges were not successful, so this is the guidance we're going to need to use in the foreseeable future when we use background check information as a part of our screening processes. So what does the employer have to prove? Essentially, the policy or practice must be job-related and consistent with business necessity. So when I say policy, this is not something that is necessarily a written part of your employment handbook or anything like that. This is just part of your regular hiring procedure. It used to be that companies would often simply exclude all applicants who checked a box stating that they had a conviction. That is exactly what the EEOC wants to avoid going forward. Now they want the employer to weigh the factors involved. So what is the nature and gravity of the offense or conduct? Certainly some felonies are more serious than others, so that needs to be weighed when we are evaluating an applicant or employee for a job. We also have to look at the time since the conviction and certainly the nature of the job held or sought. So what I mean by that is we have to specifically look at this individual and make a good faith analysis on whether any convictions in their background would make them unable to perform the duties of the job. So one example of this that I often use with my clients is if we see that someone has a felony conviction in their record from, let's say, 5 years ago for check fraud. If that individual is being considered for a bookkeeping or accounting position, it would be very reasonable to exclude that candidate under those circumstances because you have some questions on whether they could honestly perform the job and maintain the confidentiality of your financial records. If, however, that person is applying for a janitorial position, we have a much more problematic argument that that conviction is directly related to the job that's being performed. Now, there could be circumstances where that person would have access to confidential records, so it's still an issue, but these are the types of things the EEOC wants us to consider when we are evaluating an applicant and their background check information. Now, as far as an arrest, that by itself is never job-related and consistent with business necessity. So it has long been a problem under both federal and state law for employers who discount people simply because of arrest records. Now, those arrest records should not show up in a typical background check, but for whatever reason they sometimes do, or an employer can hear about this third hand during the job application process. Now, if you have arrest record information, you can consider whether the conduct the person is being accused of renders the individual unfit for the position. This is still a very high burden, though, based only on arrest record. The person has not been convicted of a crime yet. This is merely an arrest record. So we'll have to take a look at specifically what the person's doing, and we'll have to have a very high bar of showing why that would be problematic. Certainly if someone is arrested for some sort of sexual offense and they're being considered for working with a job that involves working with children, that would be a very compelling case, but it does have to be very egregious for that exclusion to apply. The other question we also receive are, what about current or pending arrests? In that case, it's not so much the issue of the arrest as it is the availability of the person to perform the work. So you never have to make an exception for someone who is arrested from your regular attendance policy. If you're looking for someone to start on July 1 and they are arrested and are unable to do so, it would be perfectly legitimate to discontinue that employment relationship simply because they're unable to show up for work. But the arrest in and of itself would not be the reason in that circumstance. As I mentioned, the EEOC is looking for that individualized assessment, and the Fair Credit Reporting Act already requires companies to provide notice to an individual if an adverse employment action is taken due to information in a background report. So the EEOC is just mirroring that requirement. We do have to provide notice to the individual why we are not hiring them if the background check information is a reason. The Fair Credit Reporting Act also requires that the applicant be able to show that that information is inaccurate and provide documentation to explain it. The EEOC has taken it a bit further and has allowed applicants to subjectively explain why they believe their criminal conviction does not render them unsuitable for the job. So we certainly have to permit them to voice their concerns, but it does not you don't have to adopt them. You can still use your business judgment and make a non-discriminatory decision to exclude that person for employment for that particular position based on the conviction if it is truly related to the job position. So as I mentioned, this is just a recap. These are the individualized assessment factors the EEOC requires that we use. First are the facts or circumstances surrounding the offense. If this is, again, is a minor incident that's unrelated to the job, then that is something that we'll have a harder time relying on when we make employment decisions. Accuracy of the criminal record, again, the applicant or employee will have the opportunity to correct the record if that is misleading or mistaken on their record. We can also look at the number of offenses for which the individual was convicted. If we have one offense decades ago and the individual has a clean history from that point forward, it's going to be much harder to exclude that applicant based on that information. We can also look at the length and consistency of employment history before and after the offense. If they've been employed steadily in the years following the offense, then that is a good indication that the conviction should not affect their job performance going forward. Rehabilitation efforts, this is also a common issue with drug convictions, which are often what come up on these background checks. If the employee shows a drug conviction but can show that they've successfully gone through rehab to where the drug issue is no longer a problem, that's something else the employer may wish to consider. And of course, any employment or character references can also be taken into account in addition to the background check information. So what does the EEOC want us to do for best practices? Certainly we have to eliminate any policies that are still out there that say we're just not going to hire felons or anyone with a criminal record. And we see this with ban the box legislation, which you might have heard about in the news recently. Currently, Michigan and Ohio have banned the ability to ask about criminal records on job applications, but that exclusion only applies to public employees. It doesn't apply to private employers yet, but some states do extend that requirement to private employers. You can still ask the question, but it is preferable to have a notice on there stating that an affirmative answer will not necessarily disqualify the applicant from employment so that we don't run afoul of this EEOC policy. In addition to that, we also have to have a narrowly tailored written policy, and this can be done by identifying essential job requirements. Once we have those effective written job descriptions, then there's no question on what the official job duties are. And then if we do have a criminal conviction that gives us pause on whether an applicant can effectively perform those essential job duties, then the EEOC is not going to question that decision. We can also look at the duration of exclusions for criminal conduct. Again, this really goes to the weight of the conviction. Certainly, if someone has a conviction for a violent offense, that is something that an employer would be well within their rights to consider for many years following that conviction. But the duration of whether to exclude based on criminal conduct would not be as long as a more minor conviction, so something of the white-collar nature if we don't have any concerns about dishonesty or fraud for the position that that person is being considered for. And I'd say the last bullet point is absolutely the most important here. All of you probably consider job applicants all the time, so it's very difficult to remember specifically why you did not allow someone to be hired for a position or did not consider them further for an interview. And you really have to record the justification for the policy. And in that case, certainly this background check information is not going to come about until post-offer when you do a specific background check. But we all know that you can sometimes get this information informally prior to that time, especially with social media. So in that case, make sure you're documenting your justification for why someone is not being hired, and make sure that documentation is very thorough. If you're not going to be hiring someone because of their criminal background, we have to have a thorough explanation on why this particular conviction prevents someone from doing that particular job. So that will be an essential part of the personnel file so that if that is later questioned, we have some information on which we can defend it. The next topic that we often see employers running into problems is with OSHA. And that's for a variety of reasons, mainly because OSHA has several new initiatives in the works that are increasing penalties and which, quite frankly, are very difficult for many employers to decipher. Pertinent to many of you who are the advanced group's clients, we wanted to bring OSHA Temporary Worker Initiative to your attention if it's something you're not already aware of. OSHA is really focusing on temporary employment relationships because it is their perception that temporary employees are sort of falling through the cracks in regard to an employer's formal safety program. So what they've done is set forth several guidance memoranda that explain what the various entities' responsibilities are with respect to maintaining the safety of temporary employees. And the overriding issue that they've really driven home here is that there is a joint responsibility between the staffing company and the client employer to maintain the safety of the temporary workers. As a part of that, each entity has various responsibilities. Notably, training is an issue that they've focused on. They've explained that the temporary staffing agency usually has a general safety training obligation to the temporary worker. So they will need to be trained on some safety best practices that would apply across any type of industry. But it is the client employer that has the responsibility to do the job-specific safety training. So certainly the client employer is in the best position to be familiar with their machinery, with their industrial processes, so they're the ones that have to make sure that the employee understands what kind of personal protective equipment is required to do a certain job and any and all other safety requirements that would extend to that company's permanent employees as well. So a question that OSHA often asks is, who is the employer for the purposes of OSHA? In most temporary staffing situations, a temp employee is on the payroll of the staffing agency. So it is common, so many people have the common misconception that the staffing agency is therefore responsible for all the traditional employment issues. But OSHA is a very different agency and they operate by different rules. OSHA considers an employer to be whatever company controls the work environment and the job duties of a particular employee. So arguing that a temporary employee is on the staffing agency's payroll as a defense to a safety violation will not get you anywhere with OSHA. So it's very important that you take various steps to protect yourself and protect the safety of the employee, just as you would for permanent employees. So in that example, you have to make sure that the temporary employee is adequately trained and qualified to perform the position where they're placed. This can be difficult for the client employer because they're often not privy to job applications, resumes, and knowledge of all the qualifications of that particular individual. So in that case, OSHA has instructed that any types of job transfers have to be communicated to the staffing company. And it's precisely for that reason, so that both parties are aware of what's going on and that the client employer has an adequate understanding of that temporary employee's qualifications to perform various jobs. So OSHA will be looking for that type of communication between the parties. They're going to be looking for training by both the staffing company and the client employer. And they're also going to be looking at the record-keeping obligations of the parties, which we'll discuss here in just a minute. OSHA record-keeping is a difficult issue for just about all employers because it can be very complex. OSHA has instructed that with regard to temporary employees, the record should be kept only in one place. So it should not be recorded at both the staffing company and the client employer. It should only be recorded on the entity that is controlling the day-to-day job duties of the employee. So oftentimes that is the client employer. So if you're in a situation where you have a temporary employee who's injured in your workforce and it meets the OSHA record-keeping definitions, that will need to go on your 300 and 301 and 300A logs that are required by OSHA. But what we see, not just with temporary employees, but with employees of any kind, is that companies don't truly understand the OSHA record-keeping obligations. So we're going to discuss those in some detail now, because what often happens is that the company gets record-keeping citations because they don't adequately maintain their records and record things that they should, or B, they're recording too much, which can lead to unnecessary OSHA inspections. So just to recap briefly, the forms listed on the slide are all the documents that a company is required to use year after year. All of the forms must be completed within 7 calendar days after receiving information that injury or illness is recordable. And that's a very important definition because too many companies make the mistake of thinking they have to record incidents within 7 calendar days of when an incident occurs. And that's not true. It's when you have information that it's recordable. Usually when these injuries occur, the employer doesn't have the type of information that they need to make that assessment. So it's fine to hold off recording it until you do. And we'll talk a little bit about the type of information that you need to make that determination in just a bit. All the forms have to be kept on file for 5 years, and that Form 300 has to be updated as changes occur and as you learn more about the incident. If you have an occupational illness, this is pretty rare. This is things like asbestosis and other types of illnesses that occur from exposure to a work environment. You also have to coordinate that in regard to workers' comp laws in the jurisdiction you're in. So for example, in Ohio, it could be up to 30 years for someone to bring an occupational disease claim. I would recommend the same thing in Michigan just because of the types of liability involved. So fortunately, although those are rare instances, those records do have to be kept much longer. And of course, these records have to be available to employees, former employees, any union reps, and to OSHA officials upon request. Now, for employees, you just have to get it to them by the end of the next business day. OSHA, however, is entitled to the records within 4 hours of their request. So you can keep these electronically, you can keep them written, but just keep in mind that you'll have to produce 5 years of these records within 4 hours if OSHA ever makes the request. Okay, so what is recordable? A lot of companies believe that every workers' comp claim is automatically OSHA recordable, and that's not the case. Oftentimes, the two are related, but it is not an absolute rule that every workers' comp claim is recordable. The definitions of recordability are very specific, and it will include any work-related injury or illness that results in death, days away from work, restricted work or transfer to another job, medical treatment beyond first aid, loss of consciousness, and a significant injury or illness diagnosed by a physician. So certainly death, we won't spend a lot of time on, that's pretty straightforward, but keep in mind that to be recordable, it does have to be related to the workplace. So, if you have a situation where someone has a long-standing illness and they happen to pass away at work, that's not going to be recordable if the work environment did not contribute to it. Same thing with something like a stroke. If that happens suddenly in the workplace and there's no connection to the work environment, that is also not recordable. Days away from work, this is another issue that companies get tripped up on. You do have to record something if an injury or illness makes people miss work, but it has to be scheduled days of work. So if the employee is not scheduled for a certain amount of time, you're not going to be recording that. It also has to be counting the day after the incident occurs. So there will be times where an employee will get injured at work and they'll be sent home and they'll miss the remainder of their shift, but they'll come back to work the next day with no restrictions. That is not recordable because you don't count that day the incident occurred. Restricted work or transfer to another job, again, just because an employee has medical restrictions does not automatically make it recordable. The restrictions have to affect a routine job duty. So if you have an employee who primarily works an office job and they sustain some sort of injury in which they're restricted from lifting over 25 pounds, that is probably not recordable because the employee is not required to routinely lift over 25 pounds for that position. So when you look at those medical restrictions, make sure they apply to the job before you record it. Medical treatment beyond first aid, this is a big one because determining what is first aid is sort of it's actually a convoluted and long definition in the OSHA regulations. So I know that no one likes to pull out their OSHA regulations and look at them, but it is section 1904.7, and there is a definition of first aid there, and it includes things that you would typically think of as first aid, like routine bandages, dressings, things of that nature. It also includes non-prescription strength medication. So if someone is just told to take Tylenol, that will fall under the first aid category. However, if they go to urgent care and they're told to take Tylenol at a dosage that is higher than the over-the-counter recommended dose, then that becomes a prescription. So it's not enough to ask a person what they were given for medication, and if they respond to Tylenol or Motrin, you have to ask the next question and ask them what the dosage is to determine if that is recordable. Another issue that confuses some people are the types of bandage that might be used as a part of treatment. Flexible bandages are always considered first aid, but if you have any type of bandage that immobilizes a limb, such as a wrist splint or anything of that nature, then it is not first aid, and it would be a recordable incident. Things like removing material from an eye or removing splinters or anything like that, that's going to be first aid unless a prescription is given to prevent infection. So a lot of employers will not record something because an antibiotic is just prescribed as a precaution, and then the employee never ends up taking it and they just return to work the next day. But unfortunately, that is still a recordable incident just because the prescription was written. It doesn't matter if the employee never filled it and never took the medication. It's enough that that prescription was written. Recordable incidents can also include things that seem to just be wholly outside of the work environment. One common example is an employee stung by a bee at the work site. If that bee sting results in an allergic reaction and an EpiPen needs to be administered, that will qualify as a recordable incident because it occurred in the workplace and because that EpiPen is a prescription treatment. So it's not always intuitive on what's recordable and what's not. It's very regulation specific, so I encourage you to take a close look at all of these before you make those types of decisions. A loss of consciousness is also a recordable incident. This is true regardless of how long someone is unconscious. So whenever you have that type of issue, that would be recordable. And a significant injury or illness, that is limited to those things described there, such as cancer, chronic irreversible diseases, fractured or cracked bones or teeth, and punctured eardrums. So that helps narrow that definition, but unfortunately, OSHA interprets even chipped teeth to qualify under this definition. So a chipped tooth would be something that would be recordable, even if there is no treatment sought for that chipped tooth. Now, there are a variety of exceptions to the recording requirement, even with these definitions. As I mentioned, if the person has a pre-existing condition and it just happens to manifest itself at work, that will not be recordable. So if someone has low blood sugar at work and that low blood sugar makes them lose consciousness for a short time, and they have diabetes as a pre-existing condition, that would not be recordable because the work environment did not contribute to it. So in addition to recordable incidents, We also have reportable incidents, which are two different obligations under the OSHA regulations. So if an incident is reportable, it is always recordable. If it meets that higher definition of reportability, you will always need to have it recorded in your 300 logs as well. But keep in mind the opposite is not always true. So just because you're writing it down in your OSHA 300 log does not mean you need to make a specific report to OSHA. So what is reportable? Reportable incidents are more serious incidents for which companies need to specifically get on the phone and call OSHA and let them know that an incident occurred. There's also an ability to report incidents online as well. But regardless of which method you choose, a company is required to report within 8 hours after the death of any employee as a result of a work-related incident. The company is also required within 24 hours after an inpatient hospitalization, an employee's amputation, or an employee's loss of an eye. If that occurs, you have 24 hours once you know that the factors are met to contact OSHA. So again, as far as the timing goes, you have 8 hours after a death or 24 hours after any of these incidents to call OSHA. But you need to know it's work-related, first of all, and you need to know the specifics on what happened. If an incident occurs and your employee is taken away by ambulance, oftentimes there's going to be a significant delay before you know whether these criteria are met. So your 8 hours and your 24 hours start ticking when you have knowledge of that these conditions exist. So let's start with the first one, the inpatient hospitalization of one or more employees. This is very difficult for many employers to figure out. HIPAA laws prevent hospitals from explaining the condition of people that are being treated there, so you can't just pick up the phone and call. And you may try to reach the employee or a family member, but oftentimes they aren't responding immediately either. So in those circumstances, you just have to make a good faith effort to find out what's going on. I would call the employee. I would call the employee's emergency contact to see what type of information you can get. Document that that call was made and when it was made. And document that no response was forthcoming. If you don't hear anything that way, you might start getting more information as workers' compensation records start coming in. Once you see from one of those medical records that a person was actually hospitalized, then you're going to know that this is a reportable incident. So if you call OSHA 3 days later, because that's when you got the information, OSHA is probably going to ask you what the delay was, but in that case you're going to be able to explain the efforts you took to find out the condition of the employee and that you finally found out about it within 24 hours of the phone call, and they're going to be satisfied that you've met your obligation in that case. Now, the reason it's difficult to decipher is because it has to be an inpatient hospitalization. So that is an admission to the hospital for treatment. It is not an emergency room visit, and it is not an admission for observation. So that because it's so particular, make sure you know that information before you're picking up the phone and calling OSHA, because once an incident like that is reported, that triggers their ability to conduct an inspection if they want to. An employee amputation will also trigger the 24-hour reporting requirement. A lot of companies have the misconception that an amputation has to involve the loss of bone, and that is not true. So even the amputation of a fingertip will be enough to trigger a reportable incident. And number 3, an employee's loss of an eye. This is the actual physical loss of an eye. It is not a loss of sight. So even if an employee is blind, that doesn't necessarily trigger the reporting requirement unless they do meet the inpatient hospitalization and have a formal admission because of that. The other issue with OSHA that a lot of companies are having problems with are with the new anti-retaliation rules. There was speculation that the Trump administration's actions would waive this rule or delay it in some way, but that is not the case. This rule is in full force and effect, and it became effective December 1 of 2016. So what the rule essentially does is it requires employers to notify their employees that they cannot be retaliated against for reporting work-related injuries and illnesses. So that has always been the law, but OSHA was never able to take any action in regard to retaliation claims unless the employee specifically filed a complaint within 30 days of the retaliation. Now, OSHA has up to 6 months to issue a citation for retaliation, and they can do it on their own without a formal employee complaint. Now, as a part of this anti-retaliation rule, OSHA explained that companies have to revise any policies that discourage an employee from reporting an injury. And they've named just a couple, three, that they claim discourages that type of injury reporting. The first one listed there is onerous reporting requirements. It was a common part of most employee handbooks to require employees to immediately report any type of workplace injury, and employers could discipline if an employee delayed in their injury reporting. OSHA has taken issue with that practice and has said that employees must have a reasonable time after discovery of an injury with which to report it. So now we need to soften that language in our policy books because there are many types of injuries that an employee might not be aware of right away, or they think they've only hurt themselves slightly and it doesn't rise to the level of a report, and OSHA has said that we need to give them that type of latitude. So in order to avoid a per se retaliation citation, just based on our policy language, we have to remove those immediate reporting requirements. We have to give them time to discover the injury first. The other issue that has been deemed problematic by OSHA is post-accident drug testing. Often many companies would automatically send their employees for drug testing after any type of injury or property damage. It is OSHA's belief that this practice discourages employees from reporting injuries because they're afraid they're going to test positive under the routine drug test. So now the company has to have a reasonable basis to believe that drugs or alcohol contributed to an incident before they send someone for a drug test. Now, under most of your drug testing policies, you probably already have a provision in there, or at least you should, that allows you to do reasonable suspicion testing. So under reasonable suspicion testing, if you see someone acting erratically or they smell like alcohol when they walk past you, that gives you reasonable suspicion that the person is under the influence and you can send them to the drug test. The OSHA standard is not that high. You don't have to smell alcohol or have someone acting erratically to send them for a drug test. You just need to have an objective, reasonable basis to believe it contributed to an accident. So in that case, OSHA wants you to make an individualized assessment rather than sending everyone for a drug test. So if you have someone who runs a forklift into a garage door, it would make sense in that situation for you to potentially send someone for a drug test because it is erratic behavior to run something into a garage door. But if an employee is stung by a bee in the facility and reports that to you, OSHA has stated that they think that that is an unreasonable situation where you would send someone from a drug test because obviously the bee sting occurred without any drugs or alcohol. They've also found that wear and tear injuries are a questionable basis to send someone for a drug test because they don't believe that any type of drug could contribute to an injury like that. So the moral of the story is that when you do send someone for a drug test, make sure that you write a note in the file explaining why you did so and why, under those particular circumstances, there was a basis to believe drugs or alcohol contributed based on the nature of the accident. The other issue OSHA is scrutinizing pretty heavily are safety bonuses. Many companies would offer their employees bonuses annually, quarterly, whenever they had 0 reported incidents. OSHA says that because we're paying them not to have recordable injuries, we're essentially discouraging them from reporting. So now those safety bonuses have to be reworked so that they're not related to reportable injuries, but are now related to something safety related in some other aspect. So those are the 3 primary anti-retaliation rule requirements that was effective December 1 of 16. So if your policies have not been revised to address those issues, I strongly encourage you to do so as soon as possible, because these are policies that OSHA will start to look at as a matter of course during their regular inspections. We also have a duty to notify employees of their rights to report, but if you have up your typical OSHA or My OSHA poster, you've already satisfied that requirement. Retaliation, not just related to OSHA, but all types of retaliation, are probably the biggest claim we see today and the highest dollar claim we receive today. And we're going to explain why here. So just last year, there were 91,503 total charges filed with the EEOC nationwide. Almost half of those were retaliation claims. And the reason for that is because the evidentiary basis for bringing a retaliation claim is much lower than it is to bring a traditional discrimination claim. A retaliation claim does not require an overt adverse employment action like a discrimination claim does. So you can have a retaliation claim even if you don't fire someone, even if you don't change their rate of pay, and even if their benefits or job title remain the same. And the reason for that is that all they have to show to succeed on a retaliation claim is that the employee, A, engaged in protected activity, and that the employer took some action with a retaliatory motive. So the action, like I said, does not need to be overt like a termination, but it has to be any action that would deter protected activity. So if you have an employee on the first shift and you transfer them to the third shift in the same position, same rate of pay, doing the exact same job duties, if they've engaged in protected activity and they can show that the transfer to the third shift is related to that protected activity, that would be enough to satisfy a retaliation claim, because many people view the third shift as being a less desirable work schedule than working on the first shift. Now, the damages we're seeing in retaliation claims are also very high, because the other disturbing aspect of retaliation claims is that because you don't need an employment termination, it is very common for the employee to keep working for you while they sue you for retaliation. And of course, you can't let them go at that point, because that would also be retaliatory. So the damages are often comprised of punitive damages. And in those cases, we are seeing multi-million-dollar jury verdicts for retaliation claims. And given the fact they're easy to prove, that plaintiffs' attorneys often get their attorney's fees paid if they are successful in these claims, these things are just skyrocketing, or they're also tacked on to a traditional discrimination claim because it's sort of a catch-all. So if they can't meet their evidentiary burden for a discrimination claim, hopefully they can meet the lower burden for a retaliation claim and be able to collect something from an employer. So how do you avoid these? Unfortunately, a lot of these happen innocently enough. an employer will just take a typical employment action and not even think it's related at all to the protected activity of the employee. However, the employee is looking for a rational basis to blame the employer for something, and they will bring the retaliation claim. Now, often those are defensible. We can get around them and we can get them thrown out, but the employer will spend tens of thousands of dollars to get to that point, paying for discovery, paying for summary judgment motions to be drafted, paying for depositions to be taken. So we want to avoid those if at all possible, not only because of your legal costs, but because of the attention it takes away to your work and the primary focus of your business. So how do we proceed with caution? Protected activity includes a lot. It does not just include claims under Title VII for discrimination or the ADA or things of that nature. Just about every protected activity is covered by some sort of federal or state law. So if an employee files a workers' comp claim, that is protected activity. We cannot fire them, certainly, for filing a workers' comp claim. We can't lay them off. We can't decide we don't want them in our building anymore because they have filed a workers' comp claim. Those are going to result in retaliation. So keep that in mind if you're thinking of making some changes in your workforce. If you have an employee who has filed a workers' comp claim in the recent past, that is the potential source of some liability, so we have to start looking for a non-discriminatory reason or some reason that is wholly unrelated to his filing of a workers' comp claim, just to make sure that we're not subjecting ourselves to liability. Taking an FMLA or other medical leave of absence is also protected activity. So we have the same thing. We need to avoid employment actions if this has occurred in the recent past. Advising of pregnancy is a big one too. It never fails that at least once or twice a month I'll get a phone call from a client and they'll say that they have this horrible employee and they're a disciplinary problem, they're an attendance problem, and I've never disciplined the employee, but I want to fire her now, and oh, by the way, she told me 2 days ago that she's pregnant. Well, that certainly ties an employer's hands. Hopefully, there is some kind of disciplinary history where this person received written warnings or had other types of discipline in their file before they advised you of the pregnancy. If that's the case, it's a little easier to move forward. If not, you could be finding yourself in a problematic situation and exposing the company to liability if you decide to take action after you've heard about the pregnancy. Certainly any kind of complaint or report of harassment is protected activity. A lot of companies get into trouble because they think this means that their complaint or report of harassment was valid. That is not true. Someone could give you a report of harassment that you investigate and you do everything you're supposed to do. You determine there is no harassment, but then they take some kind of adverse employment action against the employee for what they believe is a reason that's unrelated to the complaint, but it does still expose the company to liability if they do so too close in time to that report of harassment. So same thing with reporting a safety issue. That is prohibited under OSHA. Employees are required to, and it should be encouraged to, report unsafe conditions in the workplace, and making adverse employment changes following those reports can lead to some problems. So a common question I get after going through this with clients on a variety of issues is, how long do I have to wait after these things occur to be able to move forward? Unfortunately, there is no magic deadline that after 1 month or 3 months or 6 months, you're automatically out of the woods. Certainly, the longer period of time that passes makes the link between the adverse employment action and the protected activity weaker. but what courts are really going to be looking for are the other non-discriminatory reasons associated with the explanation. So if you are going to transfer someone because they filed a workers' comp claim, you had better have some very good documented legitimate bases for doing so that are wholly unrelated to the comp claim itself. Another big issue are managing leaves of absence, and quite honestly, we have seminars that last all day that just talk about this topic, but I'm just going to briefly touch on a few points here. Obviously, if FMLA applies, an employee is eligible for medical leave pursuant to that act, but regardless of the size of employer, and even if the employee was eligible for FMLA and exhausted all 12 weeks, they still might be entitled to a leave of absence unpaid as a reasonable accommodation under the ADA. Courts are increasingly finding that leaves of absence that are unpaid need to be granted, and often up to 6 months for employees as a reasonable accommodation. So this is difficult for a lot of companies because it's difficult for them to manage. It's difficult to have control over their workforce. But if you have sufficient protection in place, you'll be able to nip any problems in the bud and prevent employees from abusing that unpaid leave policy. So one way to do that is have a policy that requires medical documentation that shows the need for a leave. And when I say medical documentation, fortunately under the ADA, employers have a lot more latitude on the type of medical documentation that they can insist upon in order to grant this unpaid leave. Now, if this is FMLA covered, you're limited to the medical certification form and the questions answered there. But if they've exhausted FMLA or the FMLA doesn't apply to your company, you can require them to offer information from the doctor that specifically explains why they need time off from work, whether there are any other restrictions that would enable them to come to work rather than sit home, and you're also entitled to an end date. You are never required to grant someone an open-ended leave of absence. They have to have an estimated return to work date. So having those things in your policy will discourage people from abusing it and give you more control. The one thing you need to watch for is there used to be a lot of policies out there that would automatically terminate employment after a specified period of time. The EEOC and courts have found that those are problematic because you need to, again, make those individualized assessments on when these leaves will terminate and what's necessary for the individual employee. So if you still have those automatic termination things in your policy, I would recommend taking a look at that and revising that accordingly. If it's in a collective bargaining agreement, that is more permissible. But if it's just in a handbook, it can result in liability. In the policy, of course, we should prohibit conduct that's inconsistent with the need for leave. This prevents people from running a side business or doing other things that make you question whether they need to be on leave at all. And if they have FMLA or medical leaves or workers' comp leaves, the policy should state that all those things run concurrently so that they're not piling different types of leave on top of one another and basically giving them, you know, years off, and you're not able to do anything because your policies are not well written. All right, so final topic I'll touch on briefly just in our next 5 minutes here. Department of Labor news, what the Trump administration is going to do on a whole range of issues has been in the news constantly. But for our purposes as employers, these are a couple of the key things that I just wanted to bring to your attention. The first is the persuader rule. This was passed by the Obama administration a couple years ago, and it basically changed the definitions of union avoidance training and made them much broader. So now if you have an outside company come in and train your supervisors on union avoidance tactics, that was something you would have had to report to the NLRB. but we just received notice about a month ago that the Department of Labor has initiated the process of rescinding that rule. So for the time being, it's still in place, but hopefully we'll be having an end to that in the foreseeable future. A couple of guidance documents published by the Department of Labor have also been rescinded. The first is the Joint Employment Guidance that was issued in 2015. This essentially expanded the definition of joint employment so that it was found in more circumstances than it had been before. It didn't change the law at all. It just provided a more expansive interpretation of the law. That has been rescinded. We don't exactly know the effect of how that will manifest itself and whether it will be helpful to employers, but at least for the purpose of Department of Labor inspections, it's not a document that they can rely on anymore. Same thing with the independent contractor guidance. If you recall, that guidance was also issued about the same time, and it said that the preponderance is that a person will be considered an employee unless the company can show otherwise. So again, this is just not changing the law at all, but it's a guidance document that the department can no longer rely upon. So for purposes of both of these, it doesn't mean that these are issues you don't have to worry about anymore. Certainly there's a ton of case law and other regulatory decisions that still find it very difficult to satisfy independent contractor status, but that's just one issue that was pulled from agency enforcement initiatives. Opinion letters, this is an issue that the Department of Labor Secretary Alexander Acosta touched on during his testimony for confirmation. It used to be that the Fair Labor Standards Act published opinion letters on different interpretations of the law. That changed back in 2010. There were no letters written after that time, and he said he was going to start that practice again. Those letters are very helpful for employers because it gives us some more concrete examples of what is and what is not permissible under the Fair Labor Standards Act, particularly because we're relying on a statute that was written almost 100 years ago. It gives us a better glimpse into what the department considers to be compliant on more modern situations. The exempt salary level. We're sort of getting back into this. I know many of you wrestled with this last year when they discussed raising the exempt salary level to $47,476. That issue was temporarily enjoined by a court last year, so it never went into effect, but that was a temporary injunction. The court had stayed the matter because we didn't have a Department of Labor secretary confirmed for such a long time, but now that we finally do, I suspect that that litigation will get started again. The union that brought it, the AFL-CIO, is pushing that litigation, so we will see some traction and some briefs exchanged here in the near future. And finally, just something to keep in mind, there are many key positions that remain vacant, including OSHA Secretary and Wage and Hour Secretary. Even the Deputy Secretary of Labor position has not been filled. And the reason that matters to employers is that although we hear a lot in the news about regulations being rescinded, the hope that this is going to occur in the near future, particularly with regard to OSHA or Wage and Hour, is much slimmer if we don't have key people in those positions. So certainly, if you hear about it, great. Hopefully something will happen with it, but keep in mind that your obligations under those regulations continue, and they'll continue for many months because it does take a while to push those rescissions through. Well, thank you to all of you for attending, and thank you again to the advanced group for offering us this forum. I hope it's information that you found to be helpful. My contact information is listed on the slide. If you have any questions, feel free to contact me. And as I mentioned, the advanced group will be sending out certificates for recertification credit if you need that. So thank you very much and have a good afternoon.